you got into an argument. Maybe it got loud. Maybe a neighbor heard it, or somebody called 911. And before you fully understood what was happening, the police were standing in your living room. They split the two of you up. They asked a few quick questions, and then they put handcuffs on you and took you to jail. You may have not laid a hand on anybody, and now you're sitting with a charge, a court date, and a no-contact order. So what happens now? Can a case like this actually get dismissed? And what are the things that a good defense attorney is going to do to make that happen? My name is Matt Wayman with the Wayman Law Group. I handle domestic cases all of the time, all over the state of Missouri, and today I want to chat with you about how domestic assault cases get dismissed. First, let me tell you something you've probably already figured out. The system is built to keep these cases moving forward, whether you like it or not, and whether the other person likes it or not. Missouri handles cases in what is referred to as a preferred arrest situation. If officers respond and see any sign that a physical altercation has occurred, the default is to arrest somebody and let the courts figure it out later. Not because they're sure who did it. This is simply how these calls get handled. So if it feels like you were arrested first and asked questions never, you're not imagining that. And here is the part that surprises almost everyone. The state controls the charge, not the alleged victim. I get calls all the time of people that are convinced the other person can just go into the court and drop the charges. They can't. In Missouri, the decision to prosecute rests with the prosecuting attorney, not the alleged victim. Even if the victim doesn't want to prosecute the case, if the prosecuting attorney thinks that they can make their case without the victim, they can still move forward with the charges. So if your whole plan is just that the victim will go into court and drop the charges, that's not how it works. And this matters because the stakes are higher than people think, even on a misdemeanor. Missouri has 4 degrees of domestic assault. Most cases that come out of an argument get charged as 4th degree, which is a misdemeanor. But if there's an allegation of an injury, choking, or a weapon, you could be looking at a felony. And here's what almost nobody tells you up front. A domestic assault conviction in Missouri cannot be expunged, even if it's a misdemeanor, ever. It stays on your record for life. On top of that, under federal law, a domestic assault conviction can cost you your right to own a firearm for life. So this is not a pay a fine and move on situation. This is the kind of case where getting it dismissed actually changes your life. And plenty of people I represent did nothing wrong, and still they're sitting in this exact spot. So let me show you how these cases come apart. There are several tools here, and I'm going to start with the one that gets these cases resolved more than any other. The first is what we call an affidavit of non-prosecution. This is a sworn statement from the alleged victim saying that they do not want to move forward with the case. And there are 2 things that you need to understand right away. It has to be the person's own decision made freely. And it usually comes through the prosecutor's victims unit or through an attorney, not through you. You do not go get it. You cannot go get it. Hold that thought because I'm going to come back to it. And it's the most important part of this video. Now remember what I just told you. The state controls the charge, not the alleged victim. So an affidavit of non-prosecution does not automatically dismiss anything. The prosecutor can read it, set it aside, and still subpoena that person for trial. But here is why it matters so much, and how it actually plays out in the real world. When the alleged victim signs an affidavit of non-prosecution, the case usually gets set for a bench trial. That is a trial in front of a judge, not a jury. And now the state has a problem. If their witness, the person their case is built entirely on, does not show up to a bench trial, the state usually cannot prove their case. No witness, no testimony, no case. And when that happens, the judge dismisses it. Watch the ways this can go, because this is where people get it wrong. If the alleged victim does not show up for a bench trial, and the state cannot make their case without them, the case gets dismissed. If the alleged victim does show up, the case does not blow up on you. It simply gets continued. You live to fight another day. And there's a third possibility you have to respect. The state is allowed to move forward without the victim if they believe they can prove their case some other way. But here is something prosecutors understand that most defendants do not. They do not always need the victim to take the stand. They can sometimes build their case out of a 911 recording, body-worn camera footage, or things that the defendant said in the heat of the moment right after the incident. Missouri courts let some of that evidence in, even if the witness never testifies. So whether that strategy works at all depends on what other evidence that the state is holding. And that's exactly the type of thing that your lawyer evaluates early. Now back to the thing I told you to hold on to. Do not contact the alleged victim. Not to talk about the case, not to ask them to sign anything, not even to say you're sorry. In most of these cases, there is a no contact order, which means that reaching out at all is a new crime by itself. But it is worse than that. If the state can show that you pressured or influenced that person not to show up, two things can happen. One, you can be charged with witness tampering. Two, under a rule called forfeiture by wrongdoing, the judge can let every statement that person made come in anyway, even though that person never sets foot in a courtroom. This is rare, but it can happen. So the move that feels the most natural, reaching out to smooth things over, is the exact move that blows up your case. An affidavit of non-prosecution only works if it's that person's decision, made freely, handled the right way, through your attorney or the prosecutor's office. Never through you. Your job is to stay completely away from it and let your lawyer do the work. The second tool is negotiating with the prosecutor directly. Sometimes the answer is not a trial at all. A good defense attorney sits down with the state, tells them about the weaknesses in their case, and works towards a resolution. That might be an outright dismissal. It might be an amended charge down to something that's not a domestic, which matters a great deal for your record and your firearm rights. It might be a path that keeps a conviction off your record entirely. Prosecutors have large caseloads. When you give them a real reason to question whether they can win, you create room to negotiate. The third tool is depositions. This mostly comes into play on felony cases. In a felony, your lawyer can set the alleged victim for a deposition, which is a sworn statement before trial. In a misdemeanor, the rules are a bit tighter, and we have to ask the court for permission to take the alleged victim's deposition before trial. But we have that right, and here's what makes it powerful. If we set that person for a deposition and they do not show up, and we set it for a deposition again and they still don't show up, we can file a motion with the court to exclude their testimony at trial. Think about what that does. If the state's main witness won't participate at all, the state's case can come apart on its own. The fourth tool is the most satisfying one. Sometimes you can prove flat out that it didn't happen the way they claimed. Let me give you a real example of a case that I had. I had a client accused of domestic assault, and the allegations did not line up to what my client was telling me. So I brought in a private investigator. That investigator tracked down surveillance footage from a neighbor who lived directly across the street from where the incident occurred. And that surveillance footage showed definitively that what the alleged victim said happened was not true. I took that video straight to the prosecutor. Once they saw it, there was no case left to argue. The case was dismissed. Evidence like that, videos, photos, text messages, location data, can end a case faster than anything I do in the courtroom. The fifth tool is about the witness themselves. Remember, the state's case usually rests on whether or not the jury believes the person making the accusation. So part of my job is to find out who that person really is and see whether or not they're going to hold up at trial. Here's another example of a real case that I had. I had a client whose accuser had already in another state pled guilty to assaulting their domestic partner with a firearm. Think about how that lands in front of a jury. The person pointing the finger has a documented history of being the aggressor in exactly this type of situation. Once the state understood that this history was going to come out at the trial, they understood that they couldn't get a conviction. The case was dismissed. Information about the person making the accusation, a prior false allegation, a history of violence, a motivation to lie, can be the difference between a conviction and an outright dismissal. So let me bring this together. If you're charged with domestic assault in Missouri, here's what you need to remember. The state controls the charge, not the alleged victim. So this will not disappear on its own. An affidavit of non-prosecution set for a bench trial is how a large number of these cases get resolved, but only when it's the alleged victim's free choice. Beyond that, your lawyer can negotiate directly with the prosecutor, use depositions or motions to limit testimony, prove the event did not happen, or attack the accuser's credibility. And one rule you cannot break, no matter how badly you want to, do not contact the alleged victim. These cases are stressful. They move fast. And the consequences can last longer than most people think. If you have any questions or you're looking for help, please feel free to reach out at the number below. Thanks so much for tuning in.